Hey everybody, quick note to start the show. Near the end, we start discussing where are they now, about a few cases we've had on the show before and where they're at in the pipeline. And I say how a few cases have been relisted by the Supreme Court and won't be coming up again probably until the next conference, which isn't for a few weeks. And then Anya breaks in and says, don't jinx it, because two of those cases are Institute for Justice cases. Well, little did we know, but the opposite of a jinx was about to happen, because about an hour after we stopped recording this episode, the Supreme Court granted cert in one of them, Martin versus United States, a case from the 11th Circuit. So just keep that in mind, and you're listening. We, of course, didn't know that was about to happen. Now, enjoy the episode. Although it cannot be of the greatest antiquity, seeing that tea was not introduced into Britain until the middle of the 17th century and for many years thereafter was too rare and costly to be used by the great bulk of the population, the practice of reading the tea leaves doubtless descends from the somewhat similar form of divination known to the Greeks as katavos, by which fortune and love was discovered by the particular splash made by wine thrown out of a cup into a metal basin. A few spee wives still practice this method by throwing out the tea leaves into the saucer, but the reading of the symbols as they originally formed in the cup is undoubtedly the better method. Well, the Third Circuit recently seemed to indicate that officers of the law should be expected to read tea leaves if they're going to follow the Constitution and basically practice the standards that were in that reading, which is from a book called Teacup Reading and Fortune Telling by Tea Leaves by a Highland seer, published in the early 20th century. We're going to discuss today how maybe that's not the right way to interpret the Constitution and even the doctrine of qualified immunity as it stands today. And we're going to do that with a longtime friend of the show here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Monday, January 27th, 2025. And as I said, we have a longtime friend of the show coming back on Short Circuit to discuss tea leaves and the Third Circuit and qualified immunity and a few other things. But after that, we will get to another case out of the First Circuit that involves sovereign immunity, civil forfeiture, and we're also going to have a story about biker gangs I just heard about. That's not actually in the case. But that will come, who I will introduce first, and that is my friend and colleague, Anya Bidwell. So Anya, welcome back.
Hey, great to be here, especially with
who I'm about to introduce. So the last, we had a debate about this. We don't know if she's been on 3 times or 4 times.
4 times.
If she's been on 4 times, I think it's the record for a non-IJ person on Short Circuit.
Yeah.
So we're very proud of that. If it's 3 times, then it's still great. And our guest is Easha Anand. Now, Easha and her colleague at Stanford Supreme Court Litigation Clinic, where she is an assistant professor of law, her colleague, Jeff Fisher, they were both on the show about a year and a half ago, at the beginning of OT 23 Supreme Court term, where Anya went on site on Stanford and asked them about how their clinic works. Now, at that time, Easha had never argued before the Supreme Court. And now we're back a few months later, and she's done it 4 times, I think. So before we get into doing the cases of the day, I want to thank Easha for coming on and also ask, what's it like? You went from 0 to 4 in not a lot of time. Do you have any tips for oral advocates out there, and just kind of how's it been going?
So first of all, thank you both for having me. And if this is not my 4th time, if I'm not the record holder, that means you have to invite me on one more time so that I can be the record holder. Always a pleasure to be here. I'm a huge Short Circuit fan, both the newsletter and the podcast, and I'm just always grateful for the work that IJ does and love collaborating with you guys. So yes, I have been at the court 4 times since we last recorded, or maybe since we last recorded. We'll check the archives before this, put it in the show notes. And it's a dubious distinction, I have to tell you, because twice I went up to the Supreme Court because My client had petitioned, and I'd represented them at the cert stage, and the Supreme Court granted. Twice, my client had won below. And I went up to the Supreme Court, despite filing a brief in opposition, vehemently telling the Supreme Court that they should not grant cert. It's a little bit funny to sort of celebrate my time at the podium when half the time I was up there because I failed at the cert stage. But that said, it's always an honor to kind of appear before the court. I clerked there and had so much reverence for all the advocates who were standing up there, and it's really cool to kind of be among their ranks.
So is it easier on the fourth time than the first time, or is it terrifying every time?
Absolutely not. No easier. Still don't sleep the night before. Still can't eat breakfast. Still don't sleep for 2 weeks after, as I think of all the things I should have said but didn't. So no, at least doesn't get easier on time number 4. Maybe my colleague Jeff, who you referenced, just did time number 50. So maybe it gets easier by that point.
Well, we will take the pressure off by, in a moment, we'll have you discuss a case that you have nothing to do with, although it still may terrify you.
I have a breakfast advice, though. I have a breakfast advice coming from Chief Justice Roberts. I remember being super nervous, and one of the marshals, he's like, "Don't worry about it. This is all good, and you should totally eat." He's like, Chief Justice Roberts always had a cup of coffee and a half a donut, or a full donut and a half a cup of coffee.
But not both.
Fascinating.
So for all of you guys out there.
Last argument, I was like, I had this really bad, like, lingering cough. Like, I was not sick anymore. It wasn't COVID, but I just was still like coughing constantly. And I was so scared I was going to get there and just like be hacking up a lung in front of the justices. And so, when I get to the courthouse, like, the marshals look through my stuff and I have cough drops in there because I'm like so anxious this is going to happen. And so even before I get into the courtroom, food and drink in the courtroom, but I engage in this whole debate with the marshal about how cough drops should be an exception. They finally let me bring them in. So I felt like I won that kind of like statutory interpretation battle before even walking into the courtroom. TBD on the actual case I was arguing, but I did win that legal argument.
Well, at least you didn't almost cut your finger off, like our colleague Bill Maurer did before a case a few years ago, and almost passed out from losing blood in the waiting room before the Supreme Court nurse's office, which they have, I guess, bandaged him up, and then he went out and then did a terrific job. But
I clerked at the court for a year and didn't know they had a nurse's office. Wow.
Well, maybe, I don't know. Maybe it was just someone who called himself a nurse, but he got fixed up and he was okay after that. So, quick announcement before we get to the case Easha is going to talk about. Most of you probably have heard this by now, but some maybe not. It is Short Circuit's 10th anniversary. We started February 13th, 2015, at least the newsletter, and the podcast was a couple weeks later. We are having a party and show in Washington, D.C. on Thursday, April 3rd in the evening, which you're all invited to. I know a lot of people, it's Washington, D.C. How are you going to get there? I get it. But if you're in the area, we'd love to see you. Tickets are free, but they may sell out, quote unquote. So click the link in the show notes to go. There's going to be a lot of folks there you'd like to see, such as retired judges Diane Wood of the 7th Circuit, Kent Jordan of the 3rd Circuit, and Adam Liptak of the New York Times, Eugene Volokh, speaking of Stanford, of the Hoover Institution, and Rafi Melkonian, a dean of appellate Twitter, or whatever it calls itself these days, and our old friend Clark Neely, and many IJers. So if you want to see all that, plus a party, please come. But first of all, we're going to have our party that Easha is going to introduce us to of this 3rd Circuit case, which is not very fun, actually, as far as we're concerned, about qualified immunity.
Well, thanks for that introduction. So the case I want to talk about today is Rivera Guadalupe versus City of Harrisburg. So Jorge Rivera Guadalupe is arrested and charged with 9 offenses. So these range from really serious things, attempted homicide, to less serious things, firearm possession, and kind of everything in between. So he waits in jail for 18 months, at which point the government drops 5 of the charges, jury acquits him of the remaining 4. But he says the problem here is that he was detained for 18 months, and the most serious of those charges, at least, had 0 foundation, right? The fact pattern is, one evening, someone comes to the hallway of Mr. Rivera Guadalupe's rooming house, argues with Mr. Rivera Guadalupe's friend, shoots the friend in the stomach, runs away. Mr. Rivera Guadalupe goes and gets his gun and tries to chase the guy down. When a detective shows up to investigate, He interviews a few people, including Mr. Rivera Guadalupe's neighbor, all of whom tell him, guy who shot the friend was a black man. Mr. Rivera Guadalupe is Puerto Rican. He's short, he walks with a limp, two things that are not mentioned by any of the eyewitnesses, doesn't match the description at all. And all that information about Mr. Rivera Guadalupe is omitted from the warrant that the detective gets. So after he's acquitted, Mr. Rivera Guadalupe files suit, and he raises what's called a Fourth Amendment malicious prosecution claim. So he says, look, this detective essentially misrepresented the truth in order to get me arrested, to get these charges brought against me, resulted in my being detained for 18 months, when he very well knew I was not the person who did the shooting. Third Circuit panel says, yes, you have a claim, but qualified immunity. So kind of two doctrinal backdrop pieces I think we need to follow this opinion. The first is, what is a Fourth Amendment malicious prosecution claim? It's clear what a malicious prosecution claim is. The term refers to a common law tort that charged that officers initiated a criminal prosecution with malice and without probable cause, right? You set the machinery of the criminal justice apparatus in motion without cause to do so. It's a little more controversial why it's a Fourth Amendment problem as opposed to, say, the Due Process Clause problem. 3 Supreme Court Justices Gorsuch, Alito, and Thomas, actually think there is no such thing as a Fourth Amendment malicious prosecution claim. I think they're wrong, and whatever unclarity there was in prior Supreme Court decisions, the Supreme Court's decision in a case called Thompson versus Clark settles the question. There is a Fourth Amendment malicious prosecution claim. Now, Thompson doesn't go into kind of the theory behind why that is. So I'd probably commend our listeners to a case called Williams versus Aguirre, which is an 11th Circuit opinion by Chief Judge William Pryor, which I think kind of most clearly lays out the kind of theoretical foundation for how all this works. What he explains, which I think is right, is this. The Fourth Amendment contains a procedural component. A lot of justices, including Justice Scalia, have signed on to this proposition. Part of what rendered a seizure reasonable, right, that's the language of the Fourth Amendment, it's a prohibition against unreasonable seizures. Part of what rendered a seizure reasonable at the time of the founding was that there had been some sort of neutral judicial intervention, right? A warrant for an arrest or a preliminary hearing or something else where a magistrate judge was involved in authorizing a detention for any kind of length of time. And so in this context, the malicious prosecution common law tort maps onto an allegation that the judicial process you used to justify my seizure was corrupted. So, okay, Fourth Amendment malicious prosecution claim. Until recently, there was a circuit split on the following issue. Malicious prosecution requires a lack of probable cause, but what happens if you have multiple charges, right? Some courts would say, as long as one of those charges is supported by probable cause, no malicious prosecution claim, even if all the other charges have no basis, right? So you can think of extreme hypos. You've been charged with, drug possession and murder. So long as the drug possession has a foundation, doesn't matter that the cops lied to procure the murder charge. Now, in their defense, there's some intuitive appeal for that proposition. After all, when it comes to officers in the field, the Supreme Court has said, doesn't matter what charge they had in mind when they arrested you. Doesn't matter whether they in fact had any charge in mind at all. All that matters is kind of objectively speaking, there is some criminal law out there that there was probable cause to believe was violated. So that's one side of the split. The other side of the split says, no, it's a charge by charge analysis. You can look at each charge, and as to any charge that lacks probable cause, you can bring a malicious prosecution case. Now, in some cases, you'll get zero damages, right? Imagine it's the reverse in my hypothetical, right? You've got a murder charge and a drug possession charge. Turns out the murder charge is legitimate. Cops lied about the drug possession charge. Not sure why they're doing that, but just go with it. Maybe you have no damages, right? Because everything bad that happened to you, your detention, the damage to your reputation, etc., would have happened even if there had just been the legit murder charge and not the bogus drug possession charge. But you've still got a Fourth Amendment malicious prosecution claim as to the bogus charges, even if some charges are legitimate. So last term, in one of Stanford's cases called Cheverini versus City of Napoleon, the Supreme Court sides with that second camp, the charge-specific rule. So in that case, our client Yasha Shavarini. He's a master jeweler who runs a business in Napoleon, Ohio. And as part of his business, he winds up buying a ring. Turns out the ring was stolen. So he's arrested. He's charged with 2 charges that we think are illegitimate, but for which the Sixth Circuit finds probable cause, receiving stolen property and a licensing violation. But the one charge the Sixth Circuit doesn't assess is this felony money laundering charge. That charge is significantly more serious than the other 2. And it required showing that at the time Mr. Shavarini bought the ring, he knew it was stolen. Only evidence for that is one of the officers claims Mr. Shavarini confessed to knowing the ring was stolen. Here's the thing, though. The officer did not put that confession in his original police report. Weeks later, he goes back in and surreptitiously, that is, no documentation, doesn't change the date, doesn't suggest that the police report's been altered in any way. He surreptitiously goes in and adds in that line, Mr. Shavarini told me he knew it was stolen when he bought it. So at least for the stage the case is at, we can assume no probable cause for that felony money laundering charge. And that money laundering charge, I mean, boy, for a jeweler whose entire business is about trust, a wholesaler has to entrust you with thousands of dollars worth of diamonds. That money laundering charge was devastating. It meant Mr. Shavarini spent days in jail. It meant his reputation was ruined. But the Sixth Circuit says, well, there was probable cause for this minor licensing violation. There's probable cause for this misdemeanor receiving stolen property charge. So no malicious prosecution claim, even as to the significantly more serious felony money laundering charge. Supreme Court has no trouble saying that is wrong. All 6 of the justices who believe in a Fourth Amendment malicious prosecution claim sign on to that opinion. They adopt the charge-specific rule. So you go charge by charge, and if probable cause is lacking for even one such charge, you can bring a Fourth Amendment malicious prosecution claim. And that makes sense given the kind of theoretical foundations we talked about, right? So when you go to a magistrate to get a warrant or at a preliminary hearing, it's not the officer in the field situation where it doesn't matter what the charge is. You say, I think this guy, you tell the magistrate judge, right? I think this guy should be arrested or detained on XYZ charges, and the particular charges matter, right? Magistrate judge maybe would say yes to an arrest warrant if he thinks the person committed murder, and no if he thinks this is just a marijuana possession case. So the panel in Rivera Guadalupe dutifully announces that rule. Going forward, the any crime rule does not apply to Fourth Amendment malicious prosecution cases. Instead, the charge-specific rule governs. So far, so good. So the other piece of doctrinal backdrop we need here is an understanding of qualified immunity. And regular listeners of this podcast know all about qualified immunity and its pitfalls, how it's an immunity that appears nowhere in the text of Section 1983, the civil rights statute under which plaintiffs seek damages for violations of their constitutional rights, how it's abysmally ahistorical, how it seems like there is a real disconnect between how officers are trained and how they get their information on the one hand and what constitutes clearly established law on the other hand, right? For instance, George Floyd's murder is never going to be in the clearly established law bucket because that civil suit never went to trial, let alone resulted in a published circuit court case, which is what clearly established law amounts to. Yet I guarantee you, many orders of magnitude more police officers know about that case than about the latest published circuit court precedent in their circuit. Okay, so settle that aside because this podcast has extensively covered qualified immunity as a general doctrine. The specific point I want to make is this. Even ignoring all of that, right? Even if you buy qualified immunity as a general matter, the justification for the doctrine is that officers should not be held liable for conduct they could not have known was unconstitutional. Now here, there's no argument that the officer's actual conduct, right? Lying or omitting critical information on a warrant application, ignoring entirely exculpatory eyewitness testimony, and so on. There's no argument those things were unclear. Every officer knows you're not supposed to do those things.
They don't need to read tea leaves to know that's true.
Exactly. There's no need to read tea leaves to know. I mean, for decades, if not centuries, it has been clearly established, don't lie to the magistrate, right? The panel nonetheless has qualified immunity. Why? Because although it was clearly established you should not do what this detective did, that is lie on a warrant application, it was not clearly established that you could be sued for damages when you lied on a warrant application, but there was nonetheless probable cause for some charge that you didn't lie about, right? That to me is an expansion of qualified immunity, even beyond its already, to me, untenable roots. If an officer knew that what he was doing was unconstitutional, it shouldn't matter that he may not have known the vehicle for holding him accountable. So Chief Judge Pryor in the 11th Circuit talks about this in Williams. He says, quote, any doctrinal tensions concern only the relationship between the Fourth Amendment violation and the malicious prosecution. The vehicle that we have held controls liability for these violations. We have never wavered about the prohibition of misstatements in warrant applications. And I think that sort of qualified immunity creep, right? Qualified immunity, not only where there's a lack of clearly established law about the officer's actual conduct, right? The thing the officer actually did, but qualified immunity when there's something unsettled about the way you get from constitutional violation to liability, about the any crime rule, about the heck bar, about the way you figure out damages. I think that sort of qualified immunity creep is really dangerous and untenable, even if you buy all the since debunked historical and policy justifications about qualified immunity writ large. Let me pause there. Those are the two big things about this opinion I wanted to flag, and I'm so eager to hear from both of you about this case.
You know, I totally, especially what you were saying about qualified immunity, really resonates. And to our listeners, I recommend to read a concurrence by Judge Thapar in case called O'Connor versus Eubanks, where he also discusses this. And there you have an issue involving a taking, right? And Thapar says, it's clear, and everybody knows, the government must pay for what it takes, right? That's the constitutional rule. And then you should be going into all these various things that come into the liability, right? But you shouldn't be in the second prong of qualified immunity looking beyond that constitutional right and whether it was violated. It really, really creates whole bunch of problems when judges start kind of breaking that wall, right? And Thapar does a good job explaining, like, the first prong, you actually look at whether a cause of action exists. And in the second prong, you look at whether a constitutional right was clearly established. And you kind of stay disciplined about this. But court just doesn't look at it that way. And so far, every time that the question came up before the Supreme Court at the petition stage, the court denied certiorari. But this is something that is, you know, definitely important, and we should watch that space. I am worried that qualified immunity is becoming this kind of a mechanism for judges to kind of, you know, make their opinions less drastic for police officers, right? Like you hear that even like this recent case, Felix versus Barnes, that came up before the Supreme Court last week. Like the justices are like, okay, even if we rule that there is a Fourth Amendment violation, there's still qualified immunity to protect the officer, right? Tanzin versus Tanvir. The same question came up, you know, okay.
So not a holding, as we've argued in that
but
case.
But not exactly, yes. Even in Gonzalez, right, this also came up. Even if we say that, you know, the retaliation claim can proceed, they can still be protected by qualified immunity, right? So I feel like because judges treat qualified immunity as this kind of a stopgap mechanism, if everything else goes wrong, they can turn to qualified immunity, you know, because of that, they kind of purposefully keep the second prong of qualified immunity like mushy, you know, and there's a whole bunch of disagreement on various, you know, doctrines that go into the second prong, and the court continues to kind of refuse making it clear what that second prong actually stands for. I mean, we argue that it is clear that you are talking about the right and whether the right is clearly established, but there are enough cases out there in the lower courts where they're muddying those waters, and the Supreme Court is doing nothing to say, no, you should not be muddying those waters. And I do think that fundamentally, that's because they like qualified immunity as that comfort blanket. If everything else fails, we can turn to qualified immunity.
I guess like in this case, it comes down to, right, whether you define the right that is clearly established as you put it, Easha, the actual right to not have cops lie about and get you arrested, or if it's the right in context to how it can come up, basically how it can get you in trouble. So the cause of action, they'd say, well, that wasn't clearly established because of this whole like multiple charges thing. And so when I went and lied on that warrant, it wasn't clearly established that I get away with it or not.
Mm-hmm. Yeah.
And yet, I mean, I think like just thinking here, I could see why the judges maybe, if they weren't really doing their homework, were confused in this case because it is kind of complicated. But if you think to like another situation, right, like a Bivens claim, so in the federal officer context, it's perfectly clear that whether you have a Bivens claim, whether you have a cause of action, is different than whether you have qualified immunity, which was actually invented in a Bivens case. No one would say that whether or not you have qualified immunity depends on whether or not there's a Bivens claim. And maybe it hasn't come up because, of course, for the last few years, there hardly ever is a Bivens claim. So the court doesn't have to worry about distinguishing those two. But in this kind of case, because of the Supreme Court making it pretty clear at this point, and it seems like in the past, the Third Circuit was pretty clear, despite what the court says in this case. I mean, I think the law was pretty clear that there was a constitutional violation here. That's where cause of action kind of gets mixed in with qualified immunity, if not with the merits.
I think that's right. And so on the last point you just made, I thought it was pretty clear too. In fact, we put the Third Circuit on the good side of the split when we petitioned for cert in this case. And the district court in this case denied qualified immunity on the grounds that it was pretty clear in the Third Circuit. But even if you thought it wasn't clear, right, the test is not what is the officer's clearly established right to be free from liability. It's what was the plaintiff's clearly established constitutional right. And you know, these sorts of additional defenses that may be available to an officer, whether it's the heck bar, whether it's the any crime rule, whether there's a whole slew of things that an officer can point to evade liability, even where they've violated the Constitution. There doesn't need to be clearly established law on that, because the goal of qualified immunity was never to say, let's let officers violate the Constitution as long as they're not clear whether they can be sued on it. No, the goal was to say, let's protect officers who may not know they are violating the Constitution. And so even if you buy that is what qualified immunity is doing, I just think there's no warrant in a circumstance like this to impose a qualified immunity bar.
Well, sometimes you don't need to resort to qualified immunity if you're a court trying to let the government win, because there's sovereign immunity. Of course, they're very related, but we're turning now to a case that is more about the latter, and it's from the First Circuit. So, and Anya, it goes into something that, of course, fans of IJ sometimes know a lot about, which is civil forfeiture.
Yes.
So this is a case where on the criminal side of things, some people who were not treated well by the system were able to find relief, but not so much on their property through the civil forfeiture side of things.
Yes, and I have so many recommendations for the show notes, Anthony.
We will put them in there.
All right.
It'll be a read in itself.
Yes. So this is a First Circuit case. And for more background on the case, actually, watch a Netflix documentary. It's called How to Fix a Drug Scandal. Luke Ryan, who is one of the lawyers in this case, is a real hero in life and in that documentary. And so are folks at ACLU, Massachusetts, including our friend Matt Siegel, whom we should absolutely have on this show.
Absolutely, that's true.
But not 4 times, so he beats my record.
No, can't. Nobody can beat Easha's record, ever. So if we have him 4 times, then you have to keep coming, you know?
I'm just kidding.
Well, have them both on, then it's fair.
Yes, we should.
He's a hero. You should have him on as many times as you want to. Anyway, go ahead, Anya. I didn't mean to interrupt.
No, I'm now thinking about the Short Circuit special with you and Matt. But let me put that aside for now. So back to this case. Basically, for about 10 years or so, 2 state chemists in Massachusetts tampered with drug evidence and falsified drug results One chemist did that because she was an ambitious overachiever and she wanted to deliver for the government. And the other one because she was a drug addict and couldn't help herself. Through a Herculean effort by lawyers like Luke and Matt, the Massachusetts Supreme Judicial Court eventually threw out criminal cases that were tainted by these chemists.
30,000 of them. That's
yes,
insane.
30,000 of them.
That's insane.
I wouldn't have thought they'd even have 30,000 cases. I mean, that's just, wow.
30,000. Yeah, I mean, they've done it for the period of 10 years.
Mm-hmm.
Wow.
Yeah. And in addition to throwing out those 30,000 cases, the court also determined that the 14th Amendment guaranteed that these people whose cases were thrown out are owed the repayment of funds that were collected as a consequence of their convictions. So things like court costs, restitution, fines. The court said that the 14th Amendment guarantees that they get this stuff back. As to the property that was taken from them through the use of civil forfeiture, however, the court ruled that it did not need to be automatically returned because these guys' civil forfeiture judgments were not solely a consequence of their invalidated drug convictions. So instead, these individuals would need to file motions for relief from judgment under Massachusetts Rules of Civil Procedure 60B to get their property back. So our listeners, I'm sure, know that Massachusetts gets an F in our policing for profit study. The barrier to forfeit is extremely low. You only need to show probable cause that property is connected to a crime. Dogs are probable cause on 4 legs, right? Anytime a dog alerts on cash, you have probable cause that cash, connected to some crime, and cash generally has drugs, traces on cash just by its nature. And the profit incentive, by the way, is horrendous. All forfeiture proceeds, they go into law enforcement coffers. So law enforcement has an incentive to take property for civil forfeiture. So it is ironic that forfeiture funds don't get returned and other stuff that had a higher burden of proof does get returned under the 14th Amendment. So in any case, that's where this portion of the case really gets started. 2 former inmates whose convictions were thrown out filed a lawsuit in a federal court asking for an order that would require the automatic return of their forfeited property. Also, importantly, they ask for an accounting of all such property. So it's not just money, like it's a whole bunch of stuff, and they want an accounting of all that stuff, plus procedural protections. In case they have to go the Rule 60B route, they want additional procedural protections for asking for their property back. So government naturally opposes this. It argues that the 11th Amendment provides them with sovereign immunity, and also that the ex parte Young exception doesn't apply, the exception to sovereign immunity. So the First Circuit, in a per curiam decision, agrees with the government on both points. So it acknowledged that the ex parte Young exception permits a federal court to prohibit a state official from enforcing state law in a way that violates federal law, i.e. grant prospective relief that enjoins state officials from committing future violations of federal law. But here, in this case, according to the court, plaintiffs had alleged only a past wrong, not an ongoing one. Plaintiffs argued that the continuing withholding of the property is an ongoing wrong, but the court doesn't buy that. The court says that the claim rests on past actions taken at the time of their forfeiture proceedings, not the current actions, not future actions. So that means no ongoing violation, and therefore the remedy would be a retrospective and not a prospective one, so the ex parte Young exception doesn't apply. But what of the argument that ex parte Young at least covers the plaintiff's ask that they're provided some procedural protections going forward for when they ask for a relief under Rule 60B. No dice on that either, even though the district court actually agreed with the plaintiffs. The First Circuit reverses the district court and says that under Ex parte Young, plaintiffs can only seek relief from officials with some connection with the enforcement of the unconstitutional act. Otherwise, it's an 11th Amendment runaround, and what's really going on is that you are suing a state. A state is being made a party. So because the defendants here don't have the authority to alter state court procedures, the specific defendants in this case, they can't be sued for this prospective relief. Ultimately, the case is thrown out with apologies and regrets by the First Circuit. I always love how they do this kind
all
of stuff.
the good that does. Yeah.
Come on, just at least don't say unfortunately or like our sympathies. It's like, if you're gonna do this, just do this without this other stuff that doesn't help anybody. So I am hoping, though, that plaintiffs will be successful in the state court. Let's keep an eye on this, because they I'm assuming gonna go back to the state court and file 60B actions. In the meantime, I do want for us to put the policing for profit in the notes and the documentary in the notes. And I want everybody, that's homework before we see you guys next time, check out both if you haven't already.
Yeah, I mean, one thing that's so interesting about this, and you guys are the forfeiture experts, so I'd be curious to get your take. This seems to be fundamentally different from the cases the Supreme Court has identified, where they say, there's no ongoing violation, you're trying to rectify past wrong. So those are cases involving benefits or trust payments, right, where it's money in, money out. And so, the sort of seminal case is case Edelman. Someone's denied their welfare benefits for a long time, go to court, sue, and they say, now pay me our welfare benefits. And the court says, look, this is indistinguishable from a damages action, right? Like, whether you had framed this claim as, I want you to turn over the money that you've been withholding from me, or whether you said, I want damages for all the time you withheld this money from me, you would have exactly the same result. Those are indistinguishable. It's indistinguishable from the perspective of the state's sovereign immunity. This is, to me, fundamentally different, because presumably at least some of this property is just like property, right? It's someone's car, someone's house, whatever else. And so unless it's the case that the only thing confiscated was money, or any actual, any tangible property has been sold and converted into money, it strikes me this is very different, right? A damages action would say, give me the money for all the time you kept my car from me. But this action, this sort of equitable action, says, give me back my car, which seems very different to me, and so seems to fall outside the kind of reasoning of cases like Edelman. I'm curious what you guys think about that, both about the kind of underlying factual assumption I'm making, that there's something other than money at stake here, and just about, whether I'm right to say that this feels really different.
Well, this case was very unsatisfactory to me in that way. With my background is before I was at IJ was basically a trust law lawyer in employee benefits, and mostly in ERISA.
Interesting.
And so the trick of being an ERISA attorney is you're always trying to make things more equitable than legal, because you can get equitable relief under most things in ERISA and not often legal relief. And that's true in trust law generally. And so if you're trying to get, now I know that the distinction in Ex parte Young isn't strictly legal versus equitable, it's prospective relief versus damages, essentially.
Right.
And that the trick in a lot of these ERISA cases, the trick is always getting it to look like a case in equity and not just a damages action. And often you're right, that can turn on exactly what you're suing about. So if you were suing about land, that's an old-fashioned case in equity. And I'm sure they forfeited some land in all these drug cases. I mean, that's kind of par for the course in drug work in most states. There's of course going to be vehicles involved. Right. There's going to be jewelry involved. and they don't say anything about what that property is. Now, maybe there's an explanation for under ex parte Young. That's going to be considered like, say, an action in replevin, and which is a legal action and not an action for a trust. The trick in trust law is often to have it say there's a constructive trust. So you take my $10,000. It's in some bank account somewhere. Maybe it's commingled with a bunch of other cash, but it's constructively a trust that you have there. And there's absolutely no, identification of any of the nitty gritty of that property for the named plaintiffs, let alone the class members. And so, it's kind of like, wash my hands of this and we're going to move on and just say it's all essentially an action for damages. Whereas I'm sure in many ways that it's not.
It really reads like a, law school brief, right, for a competition. And it's not really deals with any of the intricacies. It's pretty blunt in terms of, we're just saying it's just like this case. So it is just like this case, rather than what Easha is talking about, where you actually have to engage with, is that actually similar to taking someone's car?
I think the ongoing, holding someone's land, that seems like an ongoing violation, especially maybe if you still have some kind of right to it. I guess the other argument is really in all those cases, say try to get my truck back, my jewelry back, whatever, constructive trust, it's all looking in the past. So whether it's legal or equitable, it just doesn't matter. It's not about the future and in any real sense, and therefore it's just ex parte Young doesn't give you a cause of action.
And that goes. Go ahead, Easha.
No, I was going to say, so I was just looking at the briefs, and they do say cars, cell phones, etc., and continue to be unlawfully withheld. So I think it's not. I think we're right to say that there's something other than money at stake, and it sounds like that's still in the state's possession. I guess it seems to me, again, kind of meaningfully different to say rectify the past wrong, which you could do by returning the property, but you could also do by just giving money, versus you are currently committing a wrong. Every day you're holding on to my cell phone and not giving it back to me. Please give me back my cell phone.
Or car, right? Like what we had, we represented a construction worker who didn't have car for 2 years. I can't even begin telling you what kind of a, rack it was on his business. That's an ongoing violation.
One other weird thing about the case that the last part you talked about, Anya, was so they couldn't get this procedural relief because they sued the wrong people. And so the real party in interest is the state high court.
I love that.
Which, of course, you can't sue under ex parte Young because they're judges. So there's just no claim in federal court at all.
Right. Which usually is the natural conclusion in all of these cases, right? But they kind of leave it unstated that fundamentally, wherever you turn, you run into an obstacle that prevents you from recovering.
And maybe that's why they didn't go into the details, because at the end of the day, you're going to lose anyway. Well, I hope these folks do get some relief in state court, and it sounds like they may. It's just going to be it's going to be a different ballgame. And then because of what happened before, right? They can't do class actions. So it's just going to be one by one. And of course, that's only going to be people who really have a lot that they lost. Their $1,000 car that they need to get to work isn't going to be worth it.
Yeah. And Western Massachusetts is a really interesting place. One of the things I want us to put on the show notes is the Springfield Police Department Narcotics Bureau, where DOJ report from a couple of years ago. And if folks are interested, they should totally read that report and see the kind of stuff that's happening there.
Well, can I just say one word about my vague familiarity with Western Massachusetts, which is not to paint with a broad brush at all, but the only time I spent in Western Massachusetts was when I was but prior to law school, I was an investigator. I worked on capital defense cases, and one of my clients belonged to a biker gang known as Freedom Riders, and a bunch of my witnesses were in Western Massachusetts. So I spent a lot of time in Western Massachusetts for that.
What's it like, hanging out with bikers in Western Massachusetts?
I learned a tremendous amount. Now when I see someone, I can read their jacket and tell you what their top rocker and their bottom rocker and their patch mean. It was deeply educational.
All right. Well, you learn everything here on Short Circuit, I suppose. I'd like to thank our Supreme Court advocate, our friend Easha Anand, for coming on, and Anya once again. We're going to close very quickly with a Where Are They Now episode of Where Are They Now? I teased an episode or two ago that there hasn't been a lot going in the Supreme Court with cases that we've already talked about, like what happened to them. But we just had an orders list come down today. So it's the end of the road, but at least we have closure. A case we talked about in Short Circuit 336, which, gosh, that was last August, Hopkins versus Watson. It was an en banc Fifth Circuit opinion about the Mississippi Constitution's denial of voting rights for felons that goes way back to post-Reconstruction times, had this really seedy racist backstory to it. It was an Eighth Amendment challenge. Anyway, that went to the Supreme Court. There was briefing. It wasn't just summarily dismissed. But finally, the order came down just this morning, and cert was denied there. Also, an update. We talked with our friend who has not been on 3 or 4 times, but he has been on twice, Joe Dietrich. He has an en banc case at the 7th Circuit, Gilbank versus Wood County. Listeners may remember this is Short Circuit 351. This is about a woman who lost her child for about a year in the child protection agencies in Wisconsin through some horrible facts, got her child back, and then sued. And that Rooker-Feldman is what was used the Rooker-Feldman doctrine to throw the case out. Well, Joe's case is now fully briefed at the court, and it's going to be up at the conference on February 21st, which I think is
the next conference.
What's that?
That's the next conference.
That's the next conference where IJ has a couple cases that are also waiting.
Yeah, don't worry about that. We're not jinxing anything.
Sorry?
We're not jinxing anything.
No jinxing, but they've been relisted 3 times now.
I don't know what you're talking about.
So, maybe pay attention when the orders list comes out from that conference.
I just remember Easha Dubin was released at many, many, many times.
That's true. Yeah.
Yeah.
There are lots of good things that come out of multiple relists, including the Andrews opinion that just came down after getting relisted for 10 straight months.
Wow.
I always tell people it's like Kremlinology, trying to figure out how the Supreme Court works.
A relist is like a box of chocolates. You never know where you're going to get. We'll see. But for now, thank you both for coming on. And please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast networks. And in the meantime, I ask you all to get engaged.